On Monday morning, a stunning new claim hit Washington. U.S. Marshals reportedly moved in and took the unredacted Epstein files straight from Attorney General Bondi's office. Not a routine records request, not a polite handoff. A physical seizure, under warrant, of material that sources say investigators feared could be altered, withheld, or destroyed. If that account is accurate, the consequences are immediate. Bondi no longer controls what may be some of the most politically explosive files in federal custody. We're talking about 847 pages, unredacted, with names allegedly still visible. But the bigger issue may not even be the files themselves. It may be what happens next. Because once the Marshals carried those documents out, the pressure shifted to the court. Judge Mon is now reportedly up against a Wednesday deadline tied to whether the warrant application gets unsealed. That is the real pressure point. We may be less than 52 hours away from learning who signed off on this move, what evidence justified it, and who inside the system decided the Attorney General herself could no longer be trusted with the material. And that's the part that changes everything. Let's walk through the sequence, because the order matters. Yesterday, on Sunday, reports began circulating that Bondi had moved the Epstein files into a personal safe inside her office. At the same time, the clock was ticking on a congressional subpoena. She supposedly had 48 hours left to comply. At that point, the likely options looked familiar. Turn over a heavily redacted version, stall, or find some procedural way to drag it out. But then, less than a day later, the situation escalated far beyond that. Roughly 19 hours after those reports surfaced, federal marshals allegedly executed a seizure warrant and removed the files entirely. That is not a normal bureaucratic dispute. That is a major escalation. And it changes the strategic landscape instantly. If the files are no longer in DOJ custody, Bondi cannot produce them to Congress even if she wanted to. She can't turn over what she no longer physically has. That means the congressional subpoena, at least in practical terms, may be overtaken by events. The documents are now reportedly in the hands of a different federal authority, which means the White House has to answer for this in public and quickly. It also suggests something else. The warrant application apparently references a whistleblower, meaning someone inside the system may have triggered this from within. So, what actually happened Monday morning? According to the reported timeline, the U.S. Marshals Service received a sealed warrant from the Southern District of New York at 6:17 a.m. By 7:43 a.m., a team had arrived at Main Justice. By 8:02 a.m., the files had been removed from the safe in Bondi's private office. Chain of custody paperwork was reportedly completed by 8:21 a.m., and by 8:34 a.m., the documents were on the way to a secure SDNY facility. Reuters is said to have obtained the execution log documenting that transfer. Every part of that timeline matters. Most importantly, the warrant reportedly came out of SDNY, not Washington. That is not a small detail. If a D.C. court had issued it, you could read this as an internal fight within DOJ circles. But if New York acted, it suggests the move came from outside Bondi's direct chain of command. In other words, someone beyond her reach may have made the decision, and the supporting details make it even more significant. The warrant application was reportedly filed under seal Friday night and approved Saturday morning by SDNY Chief Judge Laura Taylor Swain. The justification, according to the reporting, was an imminent risk that evidence could be destroyed based on credible insider testimony. The scope reportedly covered all Epstein-related documents being kept in the Attorney General's personal office. If true, that narrows Bondi's options dramatically. Imminent risk of destruction is not casual language. That is not a vague concern. That means somebody allegedly gave sworn evidence that the files were in danger, and that a judge found the risk serious enough to justify emergency action. The fact that the warrant specifically identified Bondi's private office also suggests investigators knew exactly where the material had been moved. That kind of precision does not appear out of nowhere. Somebody told them, and that leaves Bondi in a trap. If she challenges the legality of the seizure, The files stay out of her hands while the courts sort it out. If she stays quiet, she loses the chance to control redactions before Congress or the courts get involved. If she goes after the whistleblower, she effectively confirms that there was one and that the testimony mattered. However this is played, the person who set this in motion created a lose-lose situation for her. There's also evidence this was not improvised. The warrant application reportedly draws on testimony from an internal DOJ whistleblower interviewed about 2 weeks ago. According to those claims, someone in Bondi's own department told prosecutors she intended to permanently redact names before any release, not temporarily review them, not protect classified methods, permanently obscure names. And crucially, that whistleblower was allegedly interviewed by SDNY prosecutors rather than anyone in D.C., placing them outside Bondi's immediate influence. The identity of that source remains sealed, but the description of their access is telling. They reportedly knew about the transfer to the safe. They knew the timing. They even knew the alleged method that would be used to make the names disappear from any eventual release. That implies somebody close to Bondi. Very close. This does not look reactive, it looks planned. The actual removal reportedly took just 19 minutes. Bondi herself was not there. She was said to be at a breakfast meeting that had been on her public calendar for days. The Marshals allegedly arrived with a locksmith. They knew the model of the safe. They had a warrant identifying the precise location, Bondi's private office, northwest corner. That level of operational detail strongly suggests inside guidance, and the fallout started almost immediately. By 8:47 a.m., Bondi was reportedly notified by DOJ security while still at breakfast. She left at once. By 9:14 a.m., the White House press secretary had issued a statement calling the seizure an unprecedented abuse by rogue prosecutors. By 9:31 a.m., the president's personal attorney had reportedly contacted SDNY demanding the warrant be thrown out. By 10:47 a.m., Senate Judiciary Chair Dick Durbin had announced an emergency hearing for Thursday. At 11:23 a.m., a Bondi's office released a cautious statement saying the Attorney General was reviewing her legal options. By 11:58 a.m., House Oversight had moved to subpoena the seized files directly. So, in a little over 3 hours, this went from a sealed seizure to a congressional emergency. That speed tells you something important. The Marshals Service does not freelance. They move when courts tell them to move. For this operation to happen Monday morning, groundwork had to be in place well before then. That means a warrant package was likely prepared Friday, judicial approval obtained Saturday, logistics handled over the weekend, and the team briefed before dawn Monday. This was not chaos. It was organized, deliberate, and kept secret long enough to surprise almost everyone. Which brings us to Bondi's response. 4 hours after the reported seizure, she struck back. According to the filings, Bondi submitted an emergency motion in D.C. District Court, arguing that the SDNY warrant was jurisdictionally improper. She asked for the files to be returned to DOJ custody immediately, requested sanctions against the New York prosecutors for what she called forum shopping, suspended the internal whistleblower pending investigation, and scheduled a 5 p.m. press conference. That motion matters for one reason above all. Bondi is not just contesting the facts. She is attacking the court's authority to have acted at all. Her argument, in plain English, is this. A New York court has no business authorizing a seizure inside a D.C.-based Justice Department office. The goal is obvious. Get the documents back before anyone beyond DOJ reviews them and, above all, stop the warrant application from being unsealed. Because once that application becomes public, the testimony behind the seizure could become public too. The filing reportedly states that no court outside the District of Columbia has jurisdiction over DOJ's internal operations. In other words, New York can't touch us. Return the files. But there's something striking about the speed of that response. A 47-page emergency motion filed within 4 hours suggests the framework was likely prepared in advance. Bondi's team may have anticipated a legal confrontation. They just did not expect the other side to move first and move this fast. And the whistleblower suspension may be the biggest tell of all. If Bondi truly believed the warrant was obviously invalid, she could have focused entirely on jurisdiction and procedure. Instead, she also moved to sideline the internal source. That suggests the testimony is damaging enough that discrediting the witness has become part of the strategy. Even without naming the person, the announcement reportedly narrowed the field by describing them as a senior departmental employee with access to classified material. That is a small pool, and reporters are already trying to determine who is suddenly absent from DOJ headquarters. But here's the problem for Bondi. Once sworn testimony is filed, retaliation does not erase it. It simply adds another possible layer of legal exposure. If the suspension is seen as punishment for protected whistleblower activity, that creates a fresh problem entirely. And now there are multiple legal clocks running at once. The seizure itself triggers evidence preservation rules. Bondi's emergency motion creates a 48-hour response timeline in SDNY. The whistleblower suspension reportedly activates Inspector General review under federal whistleblower protections. Congress already has its own compliance and contempt timeline underway. That means 4 separate tracks are now moving simultaneously, with different deadlines and different decision-makers who do not answer to each other. If DC orders the files returned, SDNY can appeal, and the documents may remain with the Marshals during that fight. If SDNY unseals first, the whistleblower's account may enter the public record before the DC court resolves anything. If Congress moves toward contempt, the matter could escalate into a separation of powers crisis. If the Inspector General finds retaliation, the Attorney General herself could face a criminal referral. This is why the situation feels like a spiral rather than a dispute. Each move triggers another one. A former federal judge described this kind of jurisdictional battle as the sort of thing that can drag on legally for months, even though the political pressure will not wait that long. And that means there is only a short window left for any off-ramp. If Bondi backs off the motion and accepts SDNY's role, maybe there is room for a negotiated release. If she agrees to some limited production to Congress, maybe the courts slow down. If she reverses course on the whistleblower, maybe the Inspector General process cools off. But after Wednesday, those exits may disappear. Once one court acts before the other, this stops being just an Epstein files dispute and becomes a precedent fight over whether SDNY can seize evidence from Main Justice in the future. At that point, neither side will want to blink. And just when it seemed like this was a two-sided war, Bondi versus SDNY, a third force entered. On Monday afternoon, attorney Gloria Allred reportedly filed emergency motions on behalf of victims' families in both courts. That complicates everything. Why? Because the victims may have independent legal standing under the Crime Victims' Rights Act. Their interest is not the same as DOJ's and not the same as the courts. They are not arguing over jurisdiction for its own sake. They want disclosure. Their stated position is that the people harmed in the Epstein case have waited long enough and should not be forced to sit through another round of institutional secrecy while powerful offices fight over procedure. According to the motion, the request is extraordinary, that the files be disclosed directly to Victims' Counsel before either DOJ or Congress controls the process. That would effectively create a third route, bypassing both branches currently fighting over the documents. That puts fresh pressure on everyone. For Bondi, it means she is no longer just battling prosecutors and lawmakers. She is now facing a third-party group with statutory standing and enormous public sympathy. For SDNY, it raises the cost of delay, because victims' attorneys can argue that every additional day of secrecy further harms survivors. And neither Bondi nor SDNY appears to have expected this intervention. The filing reportedly includes sworn declarations from 7 survivors saying they had previously been told by DOJ officials that the names would never be released. If that is accurate, it implies a long-standing pattern of suppression reaching back across multiple administrations. One declaration allegedly says the survivor was warned that the names involved people powerful enough to ruin anyone who exposed them, and that justice would never come. That is not mere optics. That is testimony pointing toward obstruction. So step back for a second. What are the competing strategies here? Bondi appears to be trying to regain custody of the files, preserve the ability to redact names, slow the process down, and undermine the whistleblower before the supporting testimony becomes public. To do that, she seems willing to absorb reputational damage, fight the judiciary, and risk claims of retaliation. SDNY's strategy appears almost the opposite. Keep the warrant intact, keep the documents out of Bondi's hands, shield the whistleblower until the law requires disclosure, and force any unsealing on prosecutors' terms, not hers. That carries its own costs, including accusations of overreach and a possible clash with Congress and the White House. The victim's counsel, meanwhile, has the simplest position of all: disclose the names and stop the cycle of secrecy. They do not need to compromise because public sympathy is overwhelmingly on their side. And that is the core problem. There may be no outcome that satisfies all three. Somebody is going to lose decisively. Legal experts are already split on how dangerous this precedent is. Some former SDNY officials say cross-district warrants are rare but lawful when there is credible evidence that destruction is imminent. Others warn that even if this seizure was justified, it creates a model for future confrontations between prosecutors and senior officials. Yet even some conservative legal scholars reportedly concede that if the whistleblower's account is true, emergency action may have been justified. There is, of course, a counter-argument. Bondi's defenders say DOJ routinely redacts sensitive material, and that what critics are calling destruction may simply have been ordinary review. That is not a frivolous point. Redaction is normal. Protecting sources and methods is legitimate. But the key distinction is the alleged purpose. If the testimony truly says names were to be permanently obscured to shield individuals from prosecution, that is not normal redaction. That is something much darker. And that is why someone inside DOJ may have decided the risk of silence was greater than the risk of going outside the building. There's historical precedent here too, even if the facts are different. During Watergate, the country watched a chain reaction unfold when executive power collided with independent legal process. Attorneys general and senior officials were forced to choose between protecting power and following law. In that earlier crisis, the attorney general became a symbol because he resisted improper pressure. Here, if these reports are accurate, the attorney general could become the symbol for the opposite reason, not because she refused to hide evidence, but because others believed she was trying to. That is why this moment feels so serious. If the chief law enforcement officer in the country can be subjected to a court-ordered seizure by other federal actors, that means the people inside the system believed the ordinary chain of trust had already broken down. It means marshals were not enforcing law on behalf of the attorney general. They were, at least for one morning, enforcing the law against her. That is extraordinary. And if you've spent years wondering whether the most powerful people are ever truly vulnerable to consequences, that is why Monday matters. Not because accountability has fully arrived, far from it. The names are not public yet. The motions are still pending. Appeals are still likely. But the files are no longer sitting in Bondi's safe, and they are no longer hers to shape before anyone else sees them. That alone is a major change. So what happens next? Wednesday at 10 a.m. looks like the first real decision point. By then, SDNY is expected either to respond to Bondi's emergency motion or move to unseal the warrant application. There are three broad possibilities. 1. SDNY unseals. If that happens, the whistleblower's testimony could become public, and with it, the basis for the claim that Bondi intended to suppress or destroy evidence. That would likely trigger a full political firestorm. 2. SDNY opposes Bondi's motion but keeps the warrant application sealed. In that case, the jurisdictional fight could drag on for weeks while the files remain in Marshal custody. 3. The D.C. court acts first, either ordering the material returned or upholding the seizure before New York moves. That would reshape everything that follows. There are other deadlines, too. By Tuesday evening, the D.C. court may have to decide whether to schedule a hearing on Bondi's motion. The White House is reportedly weighing whether to intervene formally. Thursday morning, the Senate Judiciary Committee is set for an emergency hearing, with Bondi and SDNY prosecutors invited. Friday brings a hearing on the victims' families' motion, and the House Oversight subpoena deadline lands later that same day. These deadlines feed into each other. If SDNY unseals on Wednesday, Thursday's Senate hearing becomes a direct interrogation about the whistleblower's claims and the alleged plan to suppress the files. If SDNY delays, senators may spend Thursday battling over jurisdiction instead of substance. And if the victims prevail Friday, the entire fight could be bypassed by an independent disclosure route nobody expected at the start of the week. There are also wild cards. The whistleblower could go public before the court does. That would let them frame the story in their own words rather than through legal filings. Reports say the person has separate counsel and is considering all options. Another possibility is a leak. Hundreds of pages are now reportedly in secure custody, but secure custody still means multiple people may have some level of access. An unauthorized disclosure would be unlawful, but it would instantly change the entire story. So here is where things stand right now. The Epstein files are reportedly being held by the U.S. Marshals Service in a secure SDNY facility. Bondi's emergency motion is pending in D.C. SDNY is on the clock. The victims' families have entered the case. A Senate hearing is scheduled. House Oversight is demanding the documents. The whistleblower has been suspended but may be lawyering up for a bigger fight. The White House is considering whether to step in directly. And the Inspector General's process may already be underway because of the retaliation issue. Some things are now fixed. The files were seized. The testimony, if filed under oath, cannot be unfiled. The victim's legal standing exists whether anyone likes it or not. The subpoenas are already out. What remains uncertain is just as important. Which court moves first? Does the White House escalate this into an all-out institutional showdown? Does the whistleblower speak publicly before Wednesday? Does someone leak the documents? And perhaps most explosive of all, what names are actually in those 847 pages? That is why Wednesday morning matters so much. I'm watching three things above all. First, whether SDNY unseals or simply files an opposition and buys time. If they unseal, we may finally see what evidence supported the finding that destruction was imminent. Second, whether the whistleblower stays silent until the court acts or decides the system cannot be trusted and speaks first. Third, whether the White House chooses formal legal intervention or keeps its involvement behind the scenes. Because that decision point will tell us what this really is. If the White House enters the case directly, this becomes an open constitutional confrontation between executive power and the judiciary. If it stays in the background, Bondi may be left to fight for herself. If SDNY unseals, the factual core of the dispute may finally come into public view. If not, the legal fight continues in darkness a little longer. Either way, Wednesday at 10 a.m. is the hinge. That's when we may learn whether the whistleblower's account becomes public. That's when we may find out what Bondi was allegedly planning. That's when this story either explodes into the defining scandal of the year or sinks into a prolonged institutional war over secrecy, jurisdiction, and power. And for now, that's where we are.